Hello, everybody. My name is Mike Douglas, and I'm the chair of BHBA's Ethics and Legal Malpractice Law section. Thank you for joining us in our first CLE session of 2026. I'm delighted to introduce our speakers, Joel Osman and Adam Telanoff. Joel is a partner and the general counsel at Parker Shaffie, where he concentrates his practice on complex litigation and trials. Joel has been working for decades and brings tons of experience across professional liability, general liability, product liability, construction defect, and commercial litigation practice areas, with a particular focus on the defense of lawyers and on legal ethics. Joel has tried numerous jury trials to verdict, testifies as an expert witness, and is widely respected for his leadership in professional responsibility matters. Adam Telanoff is senior counsel at Parker Shaffie, where he focuses on professional liability and commercial litigation for clients ranging from small businesses to large enterprises. Adam brings a distinctive blend of litigation experience and in-house leadership, having successfully represented clients before administrative tribunals, arbitrations, state and federal courts across multiple jurisdictions. Adam also offers a strong business perspective shaped by his roles as general counsel and co-founder in the entertainment, finance, and technology sectors. So with that, let's get started. Joel, you want to begin?
I'll be happy to. First of all, thank you, Mike. And also thanks generally to the Beverly Hills Bar Association for the opportunity to present today. I do want to compliment Beverly Hills Bar Association. Their marketing materials are always interesting, and in this particular instance are more colorful than the title of the presentation that you're about to witness. The marketing materials talk about ethical minefields, which is a lot more sexy than our current topic. But notwithstanding the lack of sexiness in this topic, let's start. Adam, can we have the next slide, please? And the next one after that.
Yes.
Adam and Joel are adequately pretty, but that's not why we're here. Let's start with a couple of basic things. Our objectives for this exercise is to understand ethical framework for attorneys as experts and to identify conflict and confidentiality risks in those contexts. Next frame, please. In order for us to do that, we have to first start off with some brief comments about the elements of legal malpractice. And I should say in preface that we're contemplating lawyers as experts in the context of legal malpractice. So what are the elements of legal malpractice cases? Well, there are four, basically. The first one, of course, is duty. And that really boils down to the existence of an attorney-client relationship. Was there such a relationship? And if so, do duties flow from that? Generally speaking, the existence of an attorney-client relationship is a legal question for the court. You can take a look at the case cited below and the Responsible Citizens versus Superior Court case, a 1993 case. But in consideration of those factors, there are usually factual issues which underpin this determination, and courts frequently find expert testimony useful in determining those factual issues that underpin the determination. It's a little redundant. I apologize for that. Next slide, please. The second element of a legal malpractice case is breach, or as we say here, the standard of care. Did the attorney breach the applicable standard of care? Expert testimony is generally required on the issue of breach. Take a look at the O'Shea versus Lindenberg case in 2021, and also the Unigard versus O'Flaherty matter, which is a 1995 case, which tells us, among other things, that as a general rule, the standard of care against which the professional's acts are measured remains a matter peculiarly within the knowledge of experts. Once again, it's hard to conceive of a possible legal malpractice case in which there was not going to be expert testimony on the subject of breach. Anything you want to add to that, Adam?
No, I mean, technically, you may have something that's so egregious that it does not require an expert testimony, but I don't think we're ever going to run across those.
And I think generally, as a matter of, it's generally understood that you have to have an expert to establish the expert testimony to establish the elements of a legal malpractice case. I can't really imagine a situation in which even the most egregious breach of the standard of care did not require expert testimony.
And this is both the plaintiff side and defense side are going to need their experts on the issue of standard of care.
In fact, there's case law which suggests that the absence of expert testimony in a legal malpractice case, basically, you have to have the expert, and if you don't, you could be subject to a non-suit. So let's move on to the next element of our legal malpractice, and that would be causation, the third element. This is basically, but for the attorney's negligence or acts or negligent acts or omissions, the client would have achieved a more favorable result. The basic premise is set forth in Viner versus Sweet, a 2003 case. But it's worth noting for our purposes here that causation and damages are generally linked and generally require what we refer to as a case within a case analysis. That is to say, in order to prove up causation and damages, you actually have to effectively try the underlying case as part of your malpractice case. And it's more often than not, in fact, it's almost always required that there be expert testimony to establish the causal link in the case within a case analysis. Anything you choose to add on that, Adam?
No, I think it's just that this is really key, and you're not going to necessarily have the advantage of everything that was available in the underlying case, and that's a situation where the experts can come in handy to accelerate the case within a case.
Okay, then our final element of legal malpractice is damages. Generally speaking, proof of damages often hinges on expert evaluation, specifically dealing with questions of loss recovery, settlement values, or verdict potential. In most cases, plaintiffs can't merely rely. This is not an auto case where somebody could have an opinion as to how much their damages were. This is a legal malpractice case, and plaintiffs cannot rely merely on lay testimony to establish the damage element of a malpractice claim.
Yeah, and I think, and this one is the distinction between the experts who would be calculating damages and the legal malpractice expert, the attorney as an expert who would be opining about the availability of damages.
Yeah, I agree with that. By the way, we are going to be posting Q&A in the or potential questions in the Q&A section, which I don't actually see on my screen right now, but Mike will be monitoring it for us. We would like to, and I realize that people can't speak to us right now, but our plan is if we have any time at the end of the proceedings, we will take questions from the Q&A, any Q&A that's posted. So we encourage everybody to post their Q&A or their questions, and we'll get to them if the opportunity presents itself.
Yes, post your Q and we'll try and get to the A.
That's very clever. I wish I'd said that. Next slide, please. So in summary, having talked about the elements of the legal malpractice cause of action, it's pretty clear to us that attorneys are uniquely positioned as experts in the context of legal malpractice. Having said that, next slide, please.
So I guess this is where I can jump in. Attorneys are subject to the rules of professional conduct, all the professional ethical requirements, regardless of what you're doing. So presumably all of us here are attorneys. We all signed on to be governed by the ethical rules, and they impact us in everything we do, not just when we're representing a client. This goes back to the case of Librarian versus State Bar, 1943. I think everybody has probably been practicing after that date who's on this. But professional responsibilities do not turn on whether a member of the state bar acts as a lawyer. So you will find yourself subject to the ethical requirements in any capacity in which you are acting now that you are a member of the bar. Now, there are some situations when you're not acting as an attorney where there are specific rules of professional conduct. We put these here as 2.4 when you're acting as a neutral, 2.4.1, the specific neutral that is a temporary judge. Rule 3.3 has to do with candor to the court. This applies in whatever capacity you are addressing a court, not just when you are a lawyer. I know we generally think about it that way, but if you are testifying as an expert, you will be covered by 3.3. And 3.7 is when a lawyer is also acting as an advocate. There are specific rules. How about when you are acting as an expert witness? The answer is no. There is not yet a rule that governs when an attorney acts as an expert, which is why we're having this presentation.
Although,
Yep.
Okay, here we go. You actually anticipated me. Thank you very much. We don't actually yet have a rule of professional conduct which addresses lawyers acting as experts, but we do have a couple things that are worth noting. First of all, we have the interim opinion published by the Standing Committee for the California State Bar Standing Committee for Professional Responsibility and Conduct. That's interim opinion number 2000-001. That interim opinion, the public comments have closed on that. We looked in preparation for this presentation, and we couldn't find that it had actually been formally published, but I expect it will be published thereafter, shortly after this presentation. And I direct your attention to that interim opinion, which we'll discuss in the next slide. There's also an ADA formal opinion, number 97-407, which is actually in many ways quite similar to the COPRAC interim opinion 2000-0001. There are minor differences. You should be aware that neither the COPRAC opinion nor the ADA opinion are controlling authority, but presuming that both of them are ultimately finalized, they are persuasive authority, and they provide a lot of the basis for what we're going to be discussing regarding our ethical minefields here.
Yes.
Care to add, please, Adam?
No, we will be addressing those issues later on in the presentation. So this is a preview for you.
Okay, so let's take a look. We have one quote on the next slide of the interim opinion. Lawyer acting solely as a testifying expert is not representing the party on whose behalf the lawyer is testifying. This is a key and important distinction. Lawyers who are testifying as expert witness still have to adhere to the general rules of professional conduct, which Adam's already discussed in some detail.
Yeah, I think.
Go ahead, please, Adam.
Yeah, I was going to say this is something that came in and was borrowed from the ABA model rules, which spend a lot of time differentiating between a testifying expert witness and a consulting expert witness. It's something that we're going to touch on as well. But this is actually the original interim opinion has changed to specify this testifying expert witness designation. And the other key is the use of the word representing, which we're going to be addressing shortly as well.
And then finally, as we look at the comments or this quote or paraphrasing of the interim opinion, there's a key distinction that with respect to experting and confidentiality. In essence, when we serve as an expert, when we're first engaged perhaps as an expert consultant, that engagement and all the information that was provided to the potential clients in that engagement are confidential unless and until we are actually designated as expert and provide our files, the files that we've generated in connection with that designation, and ultimately testify that. Once the file is provided pursuant to a designation as an expert witness, there's no confidentiality that attaches to that file, and there's certainly no confidentiality that attaches to any testimony in connection with that file. Anything you care to elaborate on?
Yeah, I think that ties in with the representation, and we'll see that's the basis for the analysis in the interim opinion 20-0001 that we'll be getting to in just a moment.
So as a practical matter, and I think Mike mentioned in his introduction, I and a couple of my partners actually do expert engagements on a fairly regular basis. One of the things we are very cognizant of is when we do an expert engagement letter is to define the scope of our expert engagement, and to also define and make clear to the parties who are retaining us, look, we're your expert consultant unless and until you decide you want us to be your expert testifier. And there are differences in our conduct and what we can and cannot do, and what we can and cannot maintain, confidentiality that we can and cannot maintain when those differences, when you progress from being an expert consultant to being an expert testifying witness. And that's a key distinction that's going to be evident throughout our discussion this afternoon.
All right. So I think we're ready.
I'm looking at Adam, waiting
Yes.
for him to say something, and I'm not sure where he's saying it.
I am saying that ties us into the questions that we're going to be answering or attempting to answer today.
Okay. We basically have three questions, which are here in summary form, and we'll get to each separate questions. But these are basically common ethical questions, or to paraphrase from the marketing materials, these are potential ethical minefields that need to be addressed anytime a lawyer is serving as an expert. Can an attorney act as an expert in a position adverse to a former client? Second question, can an attorney act as an attorney adverse to a party for whom the attorney acted as an expert? And the final question, can an attorney act as an expert adverse to a client of their own law firm? Hopefully you guys will find this interesting and useful, and will fill up your entire hour and give you many, many insights as we do so. Kicking off to the first question, Adam, please tell us what it's about.
All right. So the first question is whether or not an attorney can act as an expert in a position adverse to a former client. And the answer is yes. But we have a star.
But it's a qualified yes.
It is a qualified yes. As with so many things in the law, we can say, yeah, but, and we'll talk about some of those buts now. And you'll notice that we're going to use a lot of that star or the asterisk to let you know that our answers are hedged. So when we're looking at the role of an attorney acting as an expert in a position adverse to a former client, we're going to start with the rules of professional conduct. And rule of professional conduct 1.9 is something that hopefully you are all familiar with in your practice. It requires a lawyer to not take a position adverse to a former client. Now, the key here is that a lawyer who has formerly represented a client in a matter shall not thereafter represent another person in the same or substantially related matter. The key term here is, of course, representation. And the question is going to be whether or not the expert is representing the client, because to the extent that you are acting as an expert or somebody is acting as an expert, they should not be representing the client. And that is an important distinction, and that distinction allows the expert to not be bound by the requirements of 1.9 that only relate to representation. But of course, there's always a caveat, and that is there may still be confidentiality issues that arise despite the fact that there is no representation in the expert witness role. In order to help us with that, we can kind of look at what's the difference between an advocate and a witness. The advocate is providing the legal advice. They're looking forward. They're kind of come up with strategy and tactics focused on the result, and I'm sure everybody here is persuasive. The witness, on the other hand, and an expert witness in particular, is not providing advice, but is providing their expert opinion. They're looking backwards at what has happened. They're not looking forwards at what is going to be happening. They should not be concerned with strategy or tactics because the expert witness is supposed to be dispassionately applying the rules and norms to the past actions. Now, these distinctions should be clean cut between being an advocate and being a witness. I think in actual practice, and Joel may want to chime in on this, that the line between being an advocate and a witness gets blurred. And one of the things that practitioners should be concerned about is helping the expert witness to maintain that distinction between acting as a witness and acting as an advocate.
Let me interject here because there are a couple of practice points here I want to point out. First of all, whenever you do an expert engagement, you obviously want to have a written engagement agreement, retainer agreement. And we think, and we certainly try to do this, it's important in that agreement to make it clear that the lawyer who's being retained to serve as an expert witness is not being retained to represent either the attorneys who have engaged him or the clients who those attorneys represent. In fact, we go to some lengths in our own practice to make sure that that distinction and that disclaimer of representation is made very, very clear in our retainer agreement. And this is one of those things, just sort of a general practice point. Your retainer agreement is your friend. It defines the scope of any engagement. It defines the limits to that scope of engagement. And in this particular instance, it defines when, for instance, whether we're representing either the attorneys or their clients, or whether we're actually serving solely as an expert. And that's an important distinction and one that you should bear in mind in any expert engagement, whether you're actually being hired as an expert or whether you're hiring an expert. Another point is you're going to see some references in the next slide to the Business Professions Code, the State Bar Act, at BNP Code Section 6000 et sec. And of course, you've already seen references to the rules of professional conduct. Just as a general reminder, the rules of professional conduct are promulgated by the State Bar and blessed by the Supreme Court. The Business and Professions Code and the State Bar Act is a creature of the legislature. The RPC and the BNP Code are substantially similar, but by virtue of the fact that they're promulgated by different organizations, there are frequently some minor differences. There's a lot of redundancy, but there is some difference. Whenever you're dealing with either the State Bar Act and the RPC, the careful practitioner wants to make sure that you look at both and are cognizant of any differences between the two. And as sort of a matter of practical reality, sometimes the motivations between the legislature and the State Bar are slightly different, and that is reflected in the differences between the RPC and the BNP Code. With that, back to you, Adam.
So, well, actually, Joel, I'm hoping you could touch on there's a pressure that arises between the attorney prosecuting the case or defending the case and the expert witness who is opining, and advertently or inadvertently, there may be efforts that push the expert out of the role of an expert and towards the role of the advocate.
Okay, that's a good point, and thank you for bringing it up again. When you're engaged as an expert, or actually when you're engaged as an attorney, and you have a limited scope engagement or any sort of engagement agreement which limits the scope of what you're going to do or not do, there's a phenomenon which we refer to in our office as mission creep. I think the mission creep is particularly potentially egregious when you're talking about an expert engagement, because when we engage as experts, whether we're testifying yet or not, whether we're merely a consultant or not, there's a lot of back and forth between the attorneys who've engaged us, their clients, and us. And that back and forth sometimes tends to push us close to the line between what we're doing as an expert and whether we're actually advocating or advising the attorneys who represent us in a way that might be considered the practice of law. Our goal as an expert is to not cross that line. And I'll tell you, as a matter of personal experience, it's really hard sometimes to keep those roles separate and to not cross the line into from one area of working as a dispassionate expert and another, crossing the line into advocacy or advice. I personally struggle with this on a regular basis and do a lot of, well, please remember, I'm not the attorney, I'm not the advocate here. I'm simply, offering you my hopefully dispassionate, hopefully not biased expert opinions. And in fact, on a personal level, one of the things I want to avoid doing, because I don't like being impeached, is I want to avoid looking in any expert engagement as if I'm actually partisan in favor of one or the other parties. My goal here is to try to look like I'm the most impartial, nonpartisan purveyor of expert opinions possible, because frankly, being impeached based upon my apparent bias is embarrassing, and I don't really want to do that. Do you have a similar experience, Adam?
I don't from the end of being the expert witness, but from being an attorney putting on a case. Very often we try and work closely with the experts in framing. So when you're dealing with a non-attorney expert, a doctor or a construction expert, any kind of expert, you really look to them to help frame the way you're going to put the case forward. And that can work in every situation except for the one where the attorney is acting as an expert witness, because the non-attorneys can never be confused with being an advocate. And so that natural propensity to help frame your case and present your case with the expert works in other situations. It doesn't work here. The other problem is the attorney expert witness, if they do start giving advice on strategy or tactics or how things may play, now you are discussing work product with a testifying expert, and everything that you tell that expert is discoverable. And now you may have inadvertently opened the door to the other side getting access to your own work product. So it's not just the expert who needs to be watching out for this, but the practitioner, the advocate, needs to be just as wary of blurring the line between the attorney expert witness as an expert and as an advocate.
Well said.
All right, so then I'll go to the next slide, which is confidentiality obligations. If you remember back, not only do we have the concerns about not blurring the line between being an expert and an advocate, but there may be confidentiality obligations that arise even though there was not representation in the role of being an expert witness. These come from Business and Professions Code 6068E1, which we all should know, but this is the obligation to maintain inviolate the confidences of a client at every peril to yourself. So this is the big one. Remember it. Don't break it. And to the extent that an expert witness has learned confidential information from a former client, they have to maintain that confidentiality. This is also reflected in RPC 1.6, which is, you can see directly referencing Business and Professions Code 6068E1. And it shows up again in RPC 1.9C, which prohibits using information that has been received from a client to the disadvantage of that former client. This can get tricky, determining whether or not the expert who is now acting adverse to a former client can do so without disclosing any of the confidences of that former client. And we get guidance here, as we do in many cases, from the cases. So let's move on. Two main cases. The first one that really we want to pay attention to is Oasis West Realty versus Goldman. It's a 2011 case. and it should be near and dear to the Beverly Hills Bar Association since it arises out of Beverly Hills and a hotel development in Beverly Hills. This is one case where we want to talk about the facts. The facts in this case are that the attorney was hired by developers to help get the necessary approvals from the city for a hotel project. However, a couple of years later, that same attorney, Goldman, was personally opposed to the project, and he joined a group of citizens who were protesting and trying to stop the development that he had worked on just a couple of years earlier. Oasis West brought a lawsuit against him. He filed an anti-SLAPP motion. This was denied by the trial court, reversed by the Court of Appeal, but ultimately the Supreme Court agreed with the trial court and said there was at least a minimal likelihood of success. And what we get out of this is the notion that even when you are not acting as an advocate, you may still be prevented from acting or open to liability for acting if you're using confidential information of a former client. This definitely could be used to trigger liability or recusal against an expert witness, and it's something to be cognizant of. And Brand versus 21st Century Insurance is a more current case, 2004, or an older case, 2004, which again looks to the substantial relationship between the lawyer's current employment and their former representation of a client, and whether or not there's an ability to keep confidential information actually separate.
Not to belabor the confidentiality thing too much, because we already talked about it some, but it's important to bear in mind that once you transition from being a expert consultant to being a testifying expert, all that confidentiality stuff stops being a factor, because everything that's been disclosed to you as a consultant, once you are designated as an expert and you produce your file for expert deposition, it's not confidential anymore. It's all part of there is no confidentiality attaches to that expert testimony once your file has been disclosed.
Yes. Thank you. All right. Well, now I'm going to turn it back to Joel.
Okay, so now let's consider, can an attorney act as an expert adverse to a party from whom the attorney has acted as an expert in a different matter? Again, we have a qualified yes. And let's talk about that qualification a little bit. We have, I'll preview this. It's not going to be a surprise, but the answer to all three of our questions are qualified yeses, which is to say, yes, you can do so, but you should be very careful about doing it. And you may actually consider whether, even if you could technically do any of these things, say yes to any of these questions, whether it's necessarily a good idea that you do so. Opinions vary as to how conservative attorneys or ethics attorneys or experts should be. On a personal level, I tend to be a very conservative ethics attorney and expert. And when in doubt, I would probably say, yeah, you could do that, but do I really want to do that? Is that really in the best interests of the people I've been hired to work for? Is it sometimes a better idea to not stretch that boundary and say, no, you would be better off having somebody else serve as your expert rather than me? That's sort of a personal mindset on my part, but I want to remind everybody that our qualified yeses here are definitely qualified. Can we see the next slide?
Yes.
So here again, we go back to RPC 1.7, one of the basic two basic conflict rules in the rules of professional conduct. The lawyer shall not, without informed written consent, and by the way, in the rules of professional conduct, anytime you see something with an asterisk, that's a defined term. Lawyer shall not, without informed written consent from each effective client, represent a client if there is a significant risk the lawyer's representation of the client will be materially limited by the lawyer's responsibilities to or relationships with another client, a former client, or a third person by the lawyer's own interest. So let's break this down a little bit. What is it actually telling us here? Well, gee, I formally represented a client as an expert, or I was formally engaged by an attorney representing a client to serve as an expert. And now I'm contemplating a new engagement against somebody against a party who was previously adverse to me. Is my representation of that client going to be materially limited by my responsibilities or relationships with the prior client, with a former client, or a third person, or by my own interests? In this instance, my own interests might be defined as, geez, be kind of embarrassing to be on, both sides of this issue and be adverse to a former client. Do I want to do that, or do I not want to do that? Your answers may vary, and I think there's actually there's a piece of this slide that's missing, Adam.
Yes, that's the,
Oops. So the key point here is, again, does this rule applies to representation, but the interim opinion and the ABA opinion tell us that you're not necessarily representing a client when you're serving as an expert. So there is an out. You could get away with it. But again, it may not be a comfortable out, and it may not be ultimately a good idea to do so. Hence the ethical minefield.
Yeah, and I think that's going to be a recurring theme that we're going to keep bringing up. And we're going to hammer it home later, I think, but it is, these rules allow you to do things. So, but the lack of a prohibition is not the same thing as being a good idea.
Speaking of recurring themes, let's get our next slide, please. No expectation of confidentiality. I don't have any expectation of confidentiality with respect to a prior engagement. I don't have any expectation of confidentiality once my new engagement turns from being an expert consultant to being a testifying expert. And furthermore, if in my prior engagement I've received confidential information, there's no expectation that I can, I have to maintain those confidences in the prior engagement, particularly if I haven't testified. But I can't expect confidentiality with respect to what I learned from those people in the new engagement. Did I say that backward, Adam?
I don't know. I was thinking about the next thing I was going to say, so I missed it. But I'm sure everybody else did.
Let's move on to the next thing you're going to say, and we won't worry about whether I said it wrong.
Well, but this is, I think, kind of the transition between a consulting expert to a testifying expert. And there is a bright line that appears. So, and it's not at the designation. So a person can be designated and then withdrawn and still maintain their status as a confidential, maintain confidentiality as a consulting expert. But once their report is turned over, then they are moving into the realm of a testifying expert. So testifying expert does not mean you're actually in court testifying or even giving a deposition. It is when your expert report is turned over to the other side.
Which probably give rise to the motion in your slide that's missing from this.
Yeah. Oh, and it does. And that was the caveat.
Well done.
It's like I practiced this or something.
Okay. Next slide, please. So in contrast, and continuing with our theme about confidentiality, there may be an expectation of confidentiality, particularly if there's you have contractual obligation to do so. Something about your engagement makes it clear by the terms of that engagement that you're obligated to maintain the confidentiality. This is particularly acute when you're talking about a potential third person, or if there's something like a protective order, which prevents use of any confidential information in your expert engagement, even if it's the subject of testimony. I don't see any motion in the slide, Alex.
Adam.
But if you
No.
have anything you want to add to that, please do.
No, I think this is just another reminder that it's not just the rules that govern. You're going to have outside forces that may require confidentiality and may impact the ability of an expert to act as an expert.
Okay, so let's turn to the next slide in this section. One more time, though, we need to revisit the Oasis West case, which tells us basically that there are two things that a lawyer is forbidden to do after severing a relationship with a former client. You can't do anything which will injuriously affect the former client in any matter in which he's formally represented him. And that could obviously apply to an expert situation. And two, you can't use the former client's knowledge or information acquired by virtue of the previous relationship, and that obviously implicates confidentiality once again. So how do we make this simpler for ourselves? Well, we understand the simplest thing to understand is that once we transition into a designated and testifying expert who's going to be producing their expert file, all that confidentiality stuff goes out the board. We can't do it. So if we're not precluded by some other contractual obligation to maintain confidentiality, once we testify or once we're designated and produce our files for testimony, there's no expectation of confidentiality and we're not going to be required to do that. But unless and until that happens, we do still have confidentiality concerns that need to be maintained. And our last question, Adam.
All right. Our last question is, can an attorney act as an expert adverse to a client of their own firm? And as Joel hinted at earlier, the answer is a yes, this time with a red asterisk, because this is really a strong caveat. This is a yes that we would prefer to say is a no, but technically it is still a yes. Where does this come in? Well, RPC 1.10 has imputation. When a lawyer is associated in a firm, none of them shall knowingly represent a client when any one of them practicing alone would be prohibited from doing so by rules 1.7 or 1.9. This makes it seem very difficult to imagine a circumstance where an attorney could be acting as an expert witness when their firm is representing the adverse client. We were trying to figure out where this could actually take place. Aside from a firm that has poor conflict checking, I'm not sure that it really could. So while it may, go ahead.
There are obviously big law and extremely large law firms which tend to have conflict waivers built into some of the things because if you've got a 3,000 lawyer law firm, not every lawyer knows every matter and every potential conflict. So they try to be very careful about their conflict checking and they try to build in waivers of such conflicts. So I suppose it's theoretically possible, but as a practical matter, and we live in a 17 lawyer law firm, so there's really no way that I would, say, yeah, technically you could do this, but there's really no way I'm going to be adverse to my own firm.
Yes. And I think that is even with the big firm, because we still have the firm-like conflict risk, and just want to touch on some of these. We're going back to RPC 1.6, which is the general duty, but this now of the entire firm to protect confidential information. And there is the need to make sure that there's insulation between the attorneys who are working with the client and getting confidential information and the expert who is acting adverse to that client, make sure that they do not have access to the confidential information, even accidentally. 1.7a, there's a prohibition of representation adverse to another client. So that would have to be addressed, and maybe you could do it with a conflict waiver. RPC 1.7b, which is a limitation on the ability of a firm to consider, recommend, or carry out an appropriate course of action. And while that would not necessarily be directly impacting the expert because he is not recommending a course of action, it could work the other way, where the expert's role on behalf of a client, especially as a consulting expert, may impact the firm's ability to represent the first client. As we touched on earlier, 1.7c1 sets forth the need to have written disclosure of conflicts. And of course, we know there's a duty of loyalty to our clients, and now you have a duty of loyalty to two opposing parties. And there's a duty of communication, which means that the firm must let both sides know, both the expert client and the adverse direct client know about the fact that the firm is taking both sides. And again, these are things that can be done. Practically, it just doesn't seem to make any sense. And that's the reason for the red asterisk when it comes to this issue of imputation. Anything else you want to talk about the firm-wide, Joel? Or I think.
No, I think we should go and recap our common ethical questions.
Well, great. Here we're going to, by the way, except we changed the format, which is why you're missing the yes to the last question. It's not an editorial mix.
Oh, I'm feeling very editorially edited. Yes. So the answers to all these questions are qualified yeses. And in the case of the last question, a really qualified yes. It's theoretically possible to do all these things. But again, is it really a good idea? Is it really going to make things better for you or for your client or for the attorneys who are retained to represent your client to do this stuff? Or is it sometimes better to just say, no, I don't want to risk the potential cross-examination. I don't want to risk the potential embarrassment of being in this situation. It's better that somebody else be the expert.
Yes.
Obviously, opinions vary. Obviously, my opinion tends towards being conservative and avoiding the potential embarrassment. Yes, it can possibly be done. Just not sure it's worth it.
No. And as the advocate, I don't want my experts to be embarrassed or cross-examined. To have it turn out through cross-examination that my expert has turned out to be just another advocate is certainly going to weaken my presentation of my case, as the jury will start discounting that expert's testimony. And I don't want that to happen as the advocate. So I think now we mentioned the ABA.
We already mentioned the ABA formal opinion. Again, remembering that that the formal opinion both for the ABA and for COPAC are not controlling authority, they're persuasive authority. And there are some minor differences both with the ABA model rules and the ABA formal opinions based upon those model rules that vary from California.
Call the operator, Adam.
That vary from California law, but as a matter of persuasive authority, I think the ABA rule, the ABA opinion and the ABA model rules are useful and basically consistent with what we've talked about today so far.
Yes, and I think one of the things that the ABA model rules do is really clarify and harp on the distinction between the consulting expert and the testifying expert.
So to sum up, let's talk about some basic points here. And we'll start with engagement agreements. We collectively firmly believe in the importance of engagement agreements for all the reasons I've already expressed. It sets the limits of your expectations with respect to what you are and are not going to do. It's a terrific opportunity to get your express disclaimers. No, I am not here to be your lawyer. I'm not here to be your advocate. I'm here solely to be your expert. I'm not here to give you legal advice. I'm simply here to be a dispassionate hopefully impartial expert. And again, in every engagement agreement, whether it's an expert agreement or a agreement to be retained as a practicing attorney on whatever the scope of whatever the engagement may be, defining the scope of that engagement is critically important. And I strongly advise people to pay attention to their engagement agreements and to pay particular attention to the defining the scope of whatever they're engaging to do, be it expert or otherwise.
And so some red flags that you should be watching out for, both as an expert and as the attorney who was hiring the expert, is whether or not you're giving access to confidential files. Remember, a consulting expert will keep those confidential, but once they become a testifying expert, whatever they have seen is now discoverable by the other side, and that can include your work product. So be very careful about what access is given. Again, looking at the vague engagement letters, we want to make sure that this is very clear, and both the advocate and the expert will want to make very clear that there are no dual roles, that the expert is acting as an expert and only as an expert, and the attorney is acting as the attorney. You want to just keep these things separate.
Let's close with a reminder of some best practices. And this is applicable, obviously, to expert engagements, but it's applicable to any engagements. First, last, and always, you want to conflict check. If there's any changes in the parties to any engagement, whether it's an expert engagement or not, you want to be sure that you rerun your conflict checks anytime there's any substantial changes, there's new parties added or anything else, you want to go back and recheck your conflict check. Number two, you want to make sure that if there are disclaimers built into your expert engagement, that they are clear and not subject to any misinterpretation and best understood by the parties at the time of the engagement. And then finally, again, this is somewhat a consistent theme in this presentation by me, is if things look questionable, if things look like they're problematic, if things look like they're going to be an embarrassment or not provide your client with the best possible opportunity to get expert testimony, just say no. I don't want to sound like Nancy Reagan, but sometimes it's just better to say no. No, I'm not the right person for this engagement for one reason or another. Find somebody else.
All right. And then the last couple of things, and I think we've harped on this in different ways. I'm just going to say it again. The role clarity is essential. We have to make sure that the expert is clearly an expert and only acting as an expert, not slipping into advocacy, that confidentiality needs to be addressed. It can't just be assumed. You have to be proactive, both as the expert and as the advocate, to make sure that we know what is supposed to be confidential, what is not, what can be disclosed and what doesn't. What is the expert allowed to discuss after the end of the representation? And that's one thing that really, I think as the practitioner, you want to be aware of is what can the expert use after they leave your employ in the broadest sense, and go on and become an expert for somebody else. And then the final thing, which again is in red, is you have to assume scrutiny. This applies across the board. It applies in this specific instance as well. Assume that other people are going to be looking at this, and the people who are looking at this are going to be adverse to you. So make sure you document, make sure everything is clear, so that when somebody else comes looking at this and trying to find a way to undermine you or your expert, that you are protected.
With that, I think we have a few more minutes left, and I haven't been monitoring the Q&A, but I will turn to Mike and ask him if there's questions that he thinks that we can address.
Yeah, there are a few questions in the chat. One question goes back to the beginning of the presentation. It was a general question about the need for expert testimony. And the question is, would missing the statute of limitations require an expert opinion, given the seeming simplicity of a statute of limitations date?
Well, as I expressed earlier, there's case law which suggests that you have to have an expert testifying in support of a legal malpractice case. So even in this particular instance where a blown statute is pretty darn obvious, I think as a matter of course, you have to have an expert. The expert's not going to have a whole lot to say if it's a clear cut of a blown statute, but I think it's probably necessary to do so. Do you feel differently, Adam?
Yeah, well, I want to expand on that a little bit because there are enough circumstances where we are not clear as to when the statute has begun or what may have taken place to toll it when we were using with a discovery issue. There can be muddling of when the statute actually runs. Also, there's the fact that the statute of limitations is an affirmative defense. And so there's a question about what happens if the other side doesn't raise the statute of limitations defense. So yes, it seems clear, but it's not always clear, and you're better off having an expert. And chances are if they blew the statute, they blew something else.
And by the way, just as an aside, we could do a whole hour just on California's statute of limitations and the issues. We're not doing that today. If we have the opportunity, we will may do it another time, but the statute of limitations at CCP 340.6 has a bunch of nuances built into it, which again augurs in favor of using an expert to testify even in a blown statute case.
So we have another interesting question in the chat. It appears it's an ongoing matter, so be careful that we're not providing legal advice here, but I'm going to read this to you. I'm an attorney who is also an architect. I had a construction case where the day prior to repair, the expert had a serious problem. I ended up going to the site and doing the architectural observation myself and prepared a report. I changed over to being an expert and assigned to an attorney in my office the continuation of the representation. And is there going to be a problem, and can I address this through agreements?
Well, first problem is going to be that if you go from being an advocate to being an expert in the same matter, you're likely to be subject to impeachment. You may also be subject to disqualification if you've changed your role. Those are the two that come off the top of my head. What do you think, Adam?
Yeah, the other one is you're still going to be compelled to comply with the ethical requirements of an attorney, even when you're acting as the architectural expert. Your status as an attorney still provides obligations that you're going to have to comply with.
And I think there's one more question, and I think this is more of a looking for a confirmation. If there's a contractual obligation to keep something confidential, what happens if the expert is testifying and is cross-examined? And same question for trial testimony, and then the person is looking to confirm that there's no confidentiality once the expert's report is submitted to the opposing counsel and the other side. So I think
you're the confidentiality guru today. Why don't you take that one?
Yeah, well, I think there's two different ones. One of them is relatively easy. Once the expert report is turned over to the other side, there's no more expectation of confidentiality. You are a testifying expert, and whatever has been provided to that expert is now discoverable. That's the easy part. The other one has to do with the confidentiality requirements when dealing with a witness, but this applies to any witness who's testifying who is subject to a confidentiality agreement. You're going to have to go look at the terms of the confidentiality agreement and probably bring some kind of a motion before the court to get permission to go beyond that confidentiality agreement. But you should start with, this is confidential and I can't disclose it.
Last question. So let's talk about the fine line between the expert becoming an advocate. So if you have an expert witness who, in the course of doing his or her work, identifies different areas of discovery that will be helpful if pursued. Is there a distinction that can be drawn that keeps the expert from switching over to advocate? For example, if the expert says to the handling attorney, here are the opinions I've developed so far. I see you haven't taken these 8 depositions and propounded this discovery. That would be very helpful for my analysis. Versus, I'd like you to go out and do this discovery because, let's say, I need this discovery to complete my analysis. So 2 different ways of saying the same thing. But what's your thought on whether or not that blurs the line between expert witness and advocate that's driving the case?
Yes, it does blur the line, and sometimes it can't be avoided. But generally speaking, and there's another line that we haven't addressed in this presentation, but there's a distinction between what the expert can say and opine about and what the expert can't say and opine about. If I don't know things, it can't be subject to my expert opinion. If I whether I want to, I can't imagine or I can't assume that I'm going to be able to answer questions about which I don't actually have information to offer the expert opinion. And if I go out and proactively say to the attorney who's retaining me as the expert, hey, I need you to figure out X, Y, and Z and answer these questions for me, I think I've probably gone over the line in terms of establishing what I'm supposed to be doing as an expert.
Yeah, and I would agree with that, and I'd be concerned that once the expert is starting to discuss who to depose, that you may be getting into having to turn over the work product of what you're asking in that deposition and how much of that came from the expert and how much of it didn't. And I just would want to stay away from that. The expert should be relying only on things that are happened, not things that could happen in the future.
Okay. Well, at this point, it's 5 o'clock. We don't have any other questions in the chat. And so I think we'll conclude our presentation. Thank you, everybody, for joining us. Thank you, Joel. Thank you, Adam. Thank you, Beverly Hills Bar Association, for hosting the seminar. Everybody, please keep an eye out. The ethics and legal malpractice law section will be pretty active this year, and so we'll have a lot of programming coming up for you. And with that, thank you very much for your time and your attention. We'll see you at the next presentation.
Bye, all.
Bye.